Hello, everybody. I am not Phil Brandt, but I am Bert Garland, shareholder at Ogletree Deacons, and welcome to This Week at Work.
This Week at Work is the only show about the workplace that offers you front row seats and a microphone, featuring experts in human resources and employment law to bring you practical, timely, and accurate insights so you can more effectively lead your organization. It's Thursday, July 11th, episode 286. Today, from wage regulations to OSHA standards, many of an employer's day-to-day activities are governed by a vast universe of federal agency regulations. The recent Supreme Court's decision on Chevron's deference could bring instability to a house of cards already built atop various interpretations of law. Special guest Jim Plunkett joins us to break down the overturning of Chevron deference and what it means for employers like you. And as always, we encourage you to get involved in the show, so speak up, take the poll, and ask your questions throughout the show. All this and more on This Week at Work.
All right, welcome back, everybody. Today is definitely going to be a special day. While it's unfortunate Phil's not with us today, I was able to get permission to extend my fast to 6 or 12 minutes of Lawyer on the Clock to virtually the entire episode. So everybody's going to get a full dose of Lawyer on the Clock today, and it's perfect timing as there's so many things to cover. As Nick alluded to earlier, you know, we were off last Thursday for the 4th of July, which means that we were on the program the last Thursday of the month of June. And wouldn't you know it, the next day, the very next day, that Friday, the Supreme Court came out with some very, very significant decisions, as they did that following Monday as well. So we've got a lot to talk about, and I can't do this alone. I wouldn't even want to, because I have a special guest with us, Jim Plunkett, my colleague. Oxford's on the ground in Washington, D.C. Welcome back to the program, Jim.
Hey, it's awesome to be back, Bert. Thanks for having me.
Of course. And as everybody on the program knows, Jim is one of my shareholder partners from Washington, D.C.'s Ogletree office, and kind of our Washington, D.C. insider. And Jim's got a lot of insight going on with respect to what's going on in Washington, D.C. these days. And I guess, you know, Jim, so I think I might have seen there's a general election coming up in a few months, isn't there?
I think so. You might have seen it in some of the news headlines, Bert. But yeah, I mean, that's certainly taken up a lot of the oxygen in Washington, D.C. these days.
I bet. In fact, I'm surprised there's even a little bit of oxygen left over for other things, but that does segue in nicely, because there are a lot of other things going on that we will have to suck some of that oxygen back into those topics here today. So before we get to Lawyer on the Clock, I want to introduce our poll question. We'd love to hear from all of you about this poll question. And everybody knows, unless you've been sleeping under a rock, and if you've been watching This Week at Work, you know that I have talked numerous times about Chevron deference and the Supreme Court potentially overturning 40 years of legal precedent known as Chevron deference. And lo and behold, the Friday after our last show, the Supreme Court did just exactly that. They overturned the Chevron deference standard. And so our poll question relates to that. And so the question is, which of the following do you believe will be impacted the most by the recent overturning of Chevron deference? And the first response is anti-discrimination policies. Second, overtime pay regulations. Third, workplace safety standards. 4, environmental compliance requirements. Or 5, other. And if you select other, we'd ask that you comment on what you think is going to be the area most impacted by the overturning of Chevron. So please put your answers in the, please select your answer and put your thoughts in the comments, and remember to submit your questions online. So I think with that, we should probably kick it over to Lawyer on the Clock segment, and we're going to do things maybe just a little bit differently today because there is so much to talk about. So like I said at the beginning, Lawyer on the Clock may run for a little bit of time today. So Nick, go ahead and let's roll with Lawyer on the Clock.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So this is going to be great today. Jim, you're going to help me tag team Lawyer on the Clock today,
Sure.
which I said may run the bulk of the episode here. And I have explained to our viewers and listeners ad nauseum about what Chevron deference is in the months and weeks leading up to the Supreme Court's decision. And I do think it was really interesting that the Supreme Court, this was really one of the last cases that it released in its term here. And of course, being the last one being released was the immunity case, as it affects the former president of the United States, President Trump, and other former presidents of the United States, or when they are former presidents. So that one will have some far-reaching consequences, but I really do want to focus on Chevron here, and people have heard me give my spiel on what Chevron is, but I'd love for them to hear another voice on this. So maybe you can set the stage of what took place about 40 years ago at the U.S. Supreme Court, and what exactly is Chevron deference?
Sure. So thanks again for having me on, Bert. I love coming on the program.
Our viewers love you.
So Chevron was a case decided in 1984 and involved Ronald Reagan's EPA, right, their Environmental Protection Agency. And when the decision came out, that sort of at that time helped what Reagan's EPA was doing, was what they were trying to regulate. Conservatives sort of applauded the decision, and so it was good for conservatives back then. And then others sort of said, and then this is just going to be another one of the boring Supreme Court decisions that we'll probably never hear from again. And so put a pin in that for just a second, and then I'll explain to you what they decided. So in Chevron, they decided when an agency is interpreting an act of Congress, a federal law that has some ambiguity, that courts should defer to that agency's interpretation. So in other words, courts would just look for a permissible interpretation that the agency took regarding that ambiguous statute, and not necessarily the best interpretation. So if I were sitting as the judge, I might say, well, that ambiguous statute, the way that the agency read it, I can think of a better way, or that they could read it, but the way they read it was permissible, so I will defer to them. And over the years, this
So Jim, let me stop you there, and let me kind of put this in the context for our viewers and listeners today. So let's take the FMLA, for example. Okay, and we all know that the Department of Labor enforces the FMLA,
right?
And so the FMLA, the statute itself, is what, maybe a few pages long. It's actually a fairly short statute.
Yep.
And so, we know that since 1993, when the FMLA came out, it is one of the most difficult pieces of federal legislation to understand. It's one of the most difficult pieces of federal legislation for employers to comply with. And so what the Department of Labor has done is they have issued regulations interpreting the FMLA. So remember, I said the FMLA, the statute itself, is just a few pages long, but we have hundreds of pages of FMLA regulations, right?
Right.
And so those are essentially the FMLA, or the Department of Labor's interpretations of what that statute means. Because when Congress passes these statutes, oftentimes there's not much to them. They sort of pass the framework of what they want the law to be, but they do not get into the specifics of how the statute should actually work, and how it should be enforced. And so then these agencies come up with their regulations, their rulemaking, et cetera, et cetera. And so in that context, we've got hundreds of pages of regulations that purport to interpret a statute that's just a few pages long. So what might this mean in that context?
Sure. So what it's going to mean is that what you described, Bert, is what I think the justices on the court, they would describe that, in the majority in the Loper-Bright decision, which overturned the Chevron case, they might say, well, what Bert described is we've got agencies who are acting as legislators, right? That they're drafting the laws, and it's Congress's job to draft laws that are clear. And for what you described, Bert, Congress drafts these statutes that end up being ambiguous for a variety of reasons. One, sometimes they do it on purpose, that they don't really understand what they're doing, and they say, well, we'll let the agency decide. Sometimes it's just sort of like legislative fatigue, or they don't really know exactly what they're legislating. They might think that they've done a good job, but once the sort of rubber hits the road, you sort of figure out there's ambiguity. And then the other reason could be that, sort of like a legislative compromise, right? That they get the ball to that 1 yard line and they can't get it over, to get that statute passed. And then they figure out a way to do it. And then they leave it up to the agencies to do the rest.
So a famous quote from a former Speaker of the House: "We have to pass it to find out what's in it," is coming back to my memory.
Right. But so what this Loper-Bright case is going to mean now for the DOL, and there's also, and we can get into this, there's all sorts of exceptions, carve-out situations in which this isn't going to apply. Not every case is going to be a Chevron Loper-Bright case, right? So I think it's important to set expectations here. But so generally what this should mean is that over time, we're going to have courts determine when there's an ambiguous statute. They're going to determine the best interpretation of that statute, and they're not going to leave it to the agencies, which are in the executive branch, which are therefore political. They're not going to let the agencies interpret it over the years, where that interpretation can change depending on who's in the White House. So theoretically, we should be getting a clearer, more predictable law developing that's determined by the branch of government that's supposed to interpret the law, and that's the federal court. So over time, this should provide some clarity and some predictability for the business community as to what their obligations are. And it should put more power back in the hands of Congress to maybe roll up their sleeves a little bit more and write some clearer rules. And it should take away some, but not nearly all power from federal agencies who are unelected, government officials and unaccountable to the public.
So you bring up a really good point there. You kept focusing on time. You kept saying overtime, and not overtime, but over time. And I want to kind of stop there for a second, because we've talked on the program many times that, and I don't mean this literally, but I do mean it, to some extent. And that is that I've often said on the program, employers almost don't care what the law is. They just want it to stop changing every 4 to 8 years when we get a new presidential administration and the executive branch changes, and therefore the people who are leading all of these administrative agencies change. And that does, as you said, make those agencies very political in nature. And so, we on the employment law side, again, we kind of want the government to tell us what the law is and then stop changing it, so that we sort of don't get caught with our hand in the cookie jar doing what we thought was correct under one administration, and then the administration changes and now we're doing something completely illegal. Right. And so So what does that mean? You kept stressing over time. What do you think the short-term impact is going to be of Chevron being overturned? And what do you see as being sort of the timeline before we start to gain some certainty here?
Sure. So, I talked about setting expectations, and there's a lot of stuff, a lot of material, a lot of ink has already been spilled about this case so far. And I always tell people, especially when you're dealing with stuff like this coming out of DC, to pump the brakes and take a deep breath, right? I always use the example of when several years ago, this goes a little bit outside of labor and employment context, but there was a regulation passed in the Obama administration regulating the internet, and it was called the net neutrality rule. And then the Trump administration came in and got rid of it. And people were saying people are literally going to die because we no longer have this regulation. And I don't think anybody has died. So I always say it's a good example of like, take a deep breath, right? Read all this stuff that's out there, but then take a deep breath. So I think on the one hand, I talked about over time, we are seeing some immediate impacts about like cases that are already in the works. And we've had, the litigants file supplemental motions and say, hey, we got to take a look at this issue now because of Loper Bright. And so courts have sort of been responding to that and, sending it back down to the lower court to reconsider in light of Loper Bright and that sort of thing. So there is some immediate impact with cases that are happening right now. But in terms of the long-term impact, we've got to wait a little bit of a while to sort of see. Courts are going to test, litigants are going to test exactly what we've decided in Loper Bright about what gets deference and what doesn't, because Chief Justice Roberts was, careful to say that there are some instances or some regulations where Congress can specifically allow and authorize deference to the agencies. And he provided examples where Congress specifically says, we'll leave this up to the secretary of such and such an agency to determine, what's included in whatever we're trying to regulate here. So they've got to figure that sort of stuff out. They've got to really understand. The courts have to sort of, and plaintiffs and litigants and the business community are going to have to over time figure out what types of regulations they're talking about in Loper Bright, what types of actions they're talking about in Loper Bright, because it does not, it's not going to impact all agencies. State action, we deal with state law all the time. That's probably going to, it doesn't necessarily apply to state law or specifically apply to state law, but, you're going to see judges probably cite to Loper Bright if there's some sort of deference in state law. To sub-regulatory activity, it doesn't appear, and that's things like enforcement memoranda or FAQs that an agency might issue or guidance that an agency might issue. I don't think Loper Bright would apply to those, but there might be some challenge to that, right? There are some agencies like the NLRB. We talk a lot about the NLRB on this program, that they were already saying, Loper Bright's not going to apply to them at all because they've been around for so long, and the deference that courts have been giving the NLRB has been established well before even Chevron was decided in 1984. So there's all these different situations, all these different agencies, all these different types of agency action that's out there. That's not necessarily all going to fit neatly into the Loper Bright bucket. But agencies and plaintiffs are going to have to test that, and that's going to take time for it to go into courts, and you might have circuit splits and all this sort of stuff. So it's going to take time for the dust to settle.
So we'll come back to that in a second here. Nick's all proud of himself, Jim, because he came up with the Filbert's forum today that he thinks is really creative. So we're going to take a quick break and let's let Nick run his Filbert's forum here. Nick, you there?
You've just entered Filbert's forum, where we peel the onion back and take a lighter look at the workplace.
So did your policies just get harder to navigate, or who's driving your compliance, or whose map will you use when you're planning your course? Nick, what do you got going on here?
Well, not to disparage away against environmental concerns and things like that, but it's almost like when you think of Chevron, first thing you think of course, is gas. So start thinking about the difference of before Chevron Deference overturned. You have maybe you're going across country and you can plan out where the gas pumps are. Okay, everything's you're going into to territories you've never been before, but you can kind of plan for it because there's gas pumps along the way. Versus you're going across country in an electric car. Oh man, where's that charging station, right? And from what I understand, Bert, you are an electric car driver. And
I am. I drive a Tesla, and I rather enjoy it.
What did you call it? A giant toy?
It's like a big, huge toy. It's like, I love when I get that alert on my phone saying there's a software update, and you can download it and start the download from your phone. And I come down to the car the next day, and it tells me what's new on the car, and the graphics have changed, and the self-driving has gotten better, and it is like a big toy. I have a lot of fun with my Tesla, but I do have I've experienced what they call range anxiety before with my Tesla, because I have taken it on 2 trips, and both times I've taken it on the trip, despite my best planning, I have needed a second stop to charge. The first stop is acceptable. The second one is painful. So it's just because you didn't plan on it, and luckily there's chargers around. But I see what you're doing here, Nick. You're trying to use the gas versus the electric as a metaphor for us heading into uncharted territory with Chevron being overturned, and I do think that's useful for us because, as you were just saying, Jim, and we'll return to what you were talking about here. It is going to take some time. I think in the short term, and maybe you can speak to this, if the DOL or the EEOC or the OSHA or the NLRB, if they show up at your door, does Chevron impact that?
No, not at all. Right? There's a time thing, and there's a time component, and then there's the trickle down component. Because even after some time, and if we start getting some clarity, it's still going to take some time for it to get through those layers of bureaucracy. But all the standards, all the regulations, all the rules that you've been following when you're on the wrong end of a government investigation, that still applies, right? So when they come knocking on your door, you got to call Bert right away. You don't say, "Hey, Chevron, the Loper Bright case happened and it got rid of Chevron, so get out of here." You just make your normal call to Bert, and he'll help you. But yeah, in the immediate day to day,
printing out Loper Bright decision and waving that in the face of the investigator is not going to be helpful if they show up at your door.
Correct.
Yeah. And I think, Jim, the way the cases work. I mean, I've got cases at the trial court level. Things definitely move faster in the federal courts than they do in state court. But, even a federal court case typically takes, on the shorter end of things, 12 months to run its course. Right. But typically closer to 18 months to maybe 2 years, maybe 2.5 years on the outside of things. So we're talking 12 months to 2.5 years for a federal court case to run its course. State court, you could be talking 2 years to 4, 5, 6 years for things to run its course. And so the point of that is that let's just stick with federal right now. Let's say you have a case that takes 18 months to wind its way through the trial court, the district court level. Then that gets appealed to the Court of Appeals, which is going to be no shorter than 6 months and probably closer to a year.
Right.
So now you're 2.5 years out. And then they may kick it back to the trial court, which then, can take another 6, 12, 18 months. Then it could go up to the Court of Appeals again. So we're talking several years before cases start to shape up within a appellate circuit. And then, of course, you have the fact that you may have different appellate circuits coming up with different rulings about the statutes that need to be interpreted, whether it be the FLSA, Title VII, the ADA, the ADEA, FMLA, as we said before, OSHA, the OSHA Act. So you've got all of this going on. You may have the circuits coming up with different rules and laws, and then that means it's going to eventually end up in the lap of the Supreme Court. I feel, and I'd be interested in your opinion on this, I feel we're it's sort of the front end of what could be a confusing and tumultuous 3, 5, maybe 10, maybe 12-year time period. I mean, we're talking a decade, I think, before we really get certainty as to what the effects are going to be of loop or bright.
I absolutely agree, Bert. Just because the Supreme Court, opines on something doesn't mean that that's the end of the issue. We've seen this happen many times. I think, affirmative action is a perfect example of that. The Supreme Court started weighing into affirmative action in the 70s. And they would have to revisit it from time to time in the 80s and the 90s, and then we had the decision from last term on the fair admissions case. So just because the Supreme Court decides it doesn't mean that that's the end of the issue. So I agree that, and for the reasons that I said, that you've got all these different types of interpretations, whether they're regulations, does it apply to state law, sub-regulatory activity? You've got all these sort of situations about whether Loper Bright and Chevron even apply. And then it's got to take time for the courts to figure those out. And then the courts also, you're not, just because you get a case at the court, you're like, hey, this is a good test for Loper Bright. You might not get a decision from the court that's very clear, right? There might be some procedural issue that the case gets knocked out on, right? Or it might go up and down, on remand and back up to the Court of Appeals. So not everything is easy and black and white in the courts. So I agree. I think we're going to be talking about this for some time, and that I wouldn't be surprised if the Supreme Court has to weigh in again to further clarify what they're talking about in Loper Bright, and what gets characterized or included under that interpretation or that case that they issued last week.
So I think, Jim, we're still likely to see this pendulum swing wildly as the executive branch changes every 4 to 8 years, at least over the course of the next decade or so, while the effects of this decision are playing out. But what I do think will eventually happen is while that pendulum will still swing, eventually it's going to stop swinging as wildly. And it's going to take a bit of time for that to happen. But I think, again, we get a decade out from this decision, and the courts have then had an opportunity to weigh in. Maybe the Supreme Court has had an opportunity to weigh in on some of these cases to give more clarity to what things look like, which should clamp down on the wild pendulum swings that we see every 4 to 8 years. We do have an audience question, and Jim, perhaps you can tackle this one. The audience member wants to know why did the Supreme Court re-examine Chevron at this time? Why go back to a 1984 case and take a look at it and say it no longer applies?
Sure. So I'll try to answer this as quick as I can. So for you, I had started to say that conservatives liked this case back in 1984, but over the years, many people have said, hey, this is giving too much power to agencies to almost be like they're like legislators and judges. They're writing the laws, they're interpreting the laws, right? And so we got to take that back, and we got to put the power where it goes, in the executive branch, in the legislative branch, and the judicial branch. And like we've just been discussing, it takes time for these sort of things to bubble up. You got to get the right facts, the right justices. So this is why it finally came to a conclusion here in Loper Bright. The particular facts of the case, we're dealing with regulating the fishing industry and it's whatever Fishing and Wildlife Services or whatever the federal agency told deep sea fishermen, like, hey, we've got all these regulations about how you got to behave when you're fishing, and we're going to put a monitor on your boat. This is what Congress said. We got to put a monitor on your boat, federal monitor, to make sure that you're following the law. And then that was all Congress said. The agency took it and said, oh yeah, and the fishermen themselves, they got to be in charge of paying that monitor, right? So the fishermen said, hey, that's crazy. We understand we got to have a monitor, but Congress didn't say who's got to pay for it. So the agency they shouldn't have the authority to say that we've got to pay for it. So those are the facts of the case, and I think they chose a pretty good case to test that with. But that's why we got Loper Bright. The one thing too I want to say, Bert, about pendulum swings and things like that is that don't underestimate the politics at play with both parties in how they push regulations. That there's a legal and regulatory component to the regulations that they push, but there's also a political opponent that they push, right? So for example, the overtime regulation that we've been talking about, right? In some ways, I think this administration doesn't care if they win either way with this regulation, because they can say, if it passes muster, they can say, hey, we gave you a raise. But if it does get struck down, they can say, hey, we tried to give you a raise, but we were stopped by perhaps Republican appointed judges. And this is why you need to vote for us in the coming elections. And, so we've seen administrations in both parties push the legal envelope, I think, when they know that their legal reasoning is dubious, but there's a political advantage for doing that. So I think you'll still see administrations pushing the envelope just because they know there's a little bit of a political victory they can secure.
Well, I think you're exactly right, and we're already seeing that, Jim, because I read a headline this morning that the acting Secretary of the U.S. Department of Labor, Julie Su, has already said that they're going to continue to press forward with rules and policies in the wake of the Supreme Court's ruling last month. She said that they're going to move forward. And she said, the quote was, we've had a number of, frankly, shocking decisions from the Supreme Court of late that are stripping away the rights of workers, the rights of women, and the rights of vulnerable communities, and the ability of the government to actually step in and help. And so they're fully intending to continue to press forward with their agenda. And not only that, we've been following on the program what's been going on down in Texas with the non-compete ban by the FTC. And the FTC, even in light of this case, has really doubled down on their non-compete rule, even after they suffered a setback down in Texas on that rule. So I think you're exactly right. We're going to see the administrative agencies plugging forward until they get reined in by the court system. I know we're just a couple minutes over. I do want to show the poll results really quickly. Interestingly, of our respondents here, people think that overturning of Chevron deference is going to most impact overtime pay regulations. Very interesting. Also, workplace safety standards. Probably not much of an impact on anti-discrimination policies or environmental compliance. Again, just wanted to share the poll results with you. Jim, I can't tell you how much I appreciate you being on. We're going to have you back and get more insight on all of this, because there's just a ton going on. You're a great co-host or guest on the program, so I appreciate you participating on the program. And with that, we will be back next week at 7:30 Central Time. And until then, go out and be good to someone.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment. LinkedIn, YouTube, Spotify, Apple Podcasts, we're everywhere you are. Don't forget you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.